don't you start? Hi guys, thanks for coming, and we're really thrilled to have Liz Sepper here. And I know you guys know about her already, and a number of folks who know you, said to say hello. But just to let you know, Liz teaches at Washington University School of Law, but is now moving over to UT Austin. She is the leading scholar of religious liberty, health law, and discrimination. You're a LAPA fellow this year, right? So she's at Princeton in the law and public affairs program there, and she and the folks at Petrie Flom have put out this book, Law, Religion, and Health in the United States. But right now she's also working on a book which she will be presenting part of today in the article that you guys got in advance. And prior to teaching, she was a fellow at the Center for Reproductive Rights at Columbia Law School, clerked for the Honorable Marjorie Rendell of the U.S. Court of Appeals for the Third Circuit, practiced at Human Rights Watch, and at NYU's Center for Human Rights and Global Justice. Anyway, so we're super delighted.
Just because we're live streaming, would you mind just doing just the last part of that?
Prior to joining the faculty, she was She was a fellow at the Center for Reproductive Rights at Columbia Law School, clerked for Marjorie Rendell in the Court of Appeals for the Third Circuit, and practiced at Human Rights Watch and at NYU's Center for Human Rights and Global Justice. And we're really thrilled to have her here, and I'm thrilled to hear about this article. So thank you.
Thank you, Christina, and thank you to Suzanne and Tanya and Erin for putting together my visit with you today. So I want to begin with a story. So a female marketing executive sits down at the bar at a nice New York City restaurant, and a waiter tells her to move to a table. A couple days later, she goes back to the same restaurant, and the same thing happens. But this time she sees a man sitting by himself eating at the bar. She finds out that the owner has barred single women from sitting at the bar due to a crackdown on prostitution. Now, this story is not unlike what Carolyn Anderson experienced in 1969 in the story that Deborah Dinner and I recount in our article. But this happened just months ago in 2019. Now, much has changed, of course, but debates continue to rage over sex, sexuality, and gender in public accommodations. Civic organizations and children's groups remain stubbornly gendered. Breastfeeding moms face accusations of indecency from business owners and customers. The bathroom wars over transgender people's access to facilities shape electoral politics. And these debates all implicate state laws prohibiting sex discrimination in public accommodations, the term of art for any entity that offers services, facilities, accommodations, or goods to the general public. 50 years ago, no law prohibited discrimination on the basis of sex in public accommodations. African American activists and their allies had fought bloody battles to win Title II of the Civil Rights Act, prohibiting discrimination based on race, national origin, color, or religion in some categories of public accommodations. But unlike Title VII of the Civil Rights Act, Title II didn't extend to sex, and does not do so today. There is no federal law prohibiting sex discrimination in public accommodations. Most states had public accommodation statutes before the Civil Rights Act, but none addressed sex discrimination. Today, however, nearly every state bars sex discrimination in public accommodations. So we know the history and the purpose of public accommodation statutes with regard to race and to a lesser extent national origin and religion. But we lack a history to inform legal and political controversies over sex in public. There's not much in the way of formal legislative history, and we don't even have the kind of socio-legal history of feminist advocacy and counter-mobilization that we have with regard to Title VII, which is often said to have no history, but has a history that we know about, right? We know about employment discrimination regarding women in 1964. So Deborah Dinner at Emory School of Law and I wrote this article to provide this historical reference point. We wanted to know, why is it that we prohibit discrimination based on sex in public accommodations, and what does sex equality mean in these spaces? So we argue that in the late 20th century, public accommodations were a central site of contestation over the legal construction of gender and the meaning of women's equality. Over the course of the 1970s, the feminist movement protested, litigated, and secured legislation against discrimination in commerce and leisure. And a wide array of women enforced these laws in administrative agencies and courts. And public accommodations laws promised a sweeping advance for women's full and equal participation in commerce and leisure, and they were understood to do three things. So first, the law would challenge the idea of a woman's place, dismantling the 19th century separate spheres ideology that assigned women to the home and men to the boardroom and the barroom. Second, non-discrimination law would free women from regulation based on sexual identity and heterosexual attachment to a man. Third, sex integration of leisure and social life might, it was hoped or feared, transform sites of dominant masculinity, like baseball and bathrooms. So I'm going to focus on those three meanings, but first let me give you a lay of the legal and customary landscape. So in 1969, our three themes, the kinds of commercial spaces in which the madmen of the business world congregated, your expensive restaurants, men's clubs, refused to open their doors to women. Bars and diners posted signs, "No unescorted ladies allowed." Women were not welcome in many organizations that shaped civic life or fueled business connections like Rotary clubs, Boy Scouts, and golf courses. Credit and insurance companies subsumed women's economic identities under those of their husbands, denying married women credit in their own names and setting, for example, auto insurance rates based on husbands' driving records alone. So over the course of the 1970s, feminist advocacy dismantled much of this sex segregation. As they began this campaign, the nascent feminist movement built on a foundation developed by African American women in the civil rights movement who sought to fight racial and gender oppression simultaneously. These women, including Polly Murray and Anna Arnold Hedgeman, became founders of the National Organization for Women, or NOW, in 1966, which swiftly became one of the leading national organizations fighting for sex equality. Public accommodations held a prominent place in NOW's early agenda. A wide cross-section of women and girls across class and racial backgrounds recognized the wrong of public accommodations denial, whether in a bank, tavern, baseball diamond, or diner, and the importance of winning sex equality. Now, the leaders of this campaign, however, were predominantly white, middle-class women who had begun to advance in their professional careers only to find themselves outside the intangible networks that held up the glass ceiling. So drawing explicitly on analogies to the sit-ins and Black freedom struggles, NOW spearheaded protests against public accommodations discrimination on the basis of sex. They held eat-ins, they negotiated with business owners, and strategically deployed the media. They litigated under the Equal Protection Clause prior to statutory prohibitions on sex discrimination in the famous McSorley's Old Ale House case. This is in New York City. They fought for legislative change, and by 1975, 27 states had passed laws banning sex discrimination in public accommodations. Pretty swift social movement success and legislative change. So the feminist campaign operated in part by making discrimination visible. At the beginning of this time period, when their campaign began around 1968, critics of the women's movement often argued that it just couldn't provide concrete evidence of discrimination in any field but employment. And these protests produced just such evidence, making visible something that was so pervasive, people just couldn't see it. So feminists had the most success in dismantling the separate spheres ideology embodied in men-only business lunches and the men's grills of the time. So women who had achieved some professional success found that when their male colleagues or clients wanted to go to lunch, there were many places, maybe most places in many urban areas, that would not serve them between the hours of 11 and 2. Protesting the high-class Oak Room at the Plaza Hotel, Betty Friedan, one of Now's famous founders, remarked that she and other women had tried to enter the establishment for business lunches with male colleagues only to face the embarrassment and insult of being informed that men alone could enter. And other high-end hotels, like the Fairmont, a venue that solicited women's wedding business but banned them at lunch, faced protests. And here's one of the signs of the times. Now, the connection between this sort of social exclusion and employment opportunity was particularly stark in a number of professional organizations, in particular press clubs, which often excluded women journalists from major events or from certain spaces where contacts and leads were exchanged, like the cocktail bar area of the press club. Now, one of our favorite examples of the custom of separate spheres is United Airlines male-only executive flight. It was a route from Chicago to Newark. And it was justified quite literally by United as a place where men could relax and loosen their ties away from women, because, of course, you cannot loosen your tie on a commercial airliner, as we all know. So, of course, there were women on this flight, but they were the flight attendants. Now, Betty Friedan, Now's famous founder and a frequent flyer, and many professional women swore not to fly the friendly skies of United until they ended this route, which they did fairly swiftly. Now, fairly swiftly from 69 to 70, but I have a letter from a female executive from 1958 protesting this route. So women were aware of this practice. But United just didn't care. There weren't enough women executives yet in 58. Now, some degree of economic and racial privilege shaped both the experience of sex discrimination and the way in which these women protested. So, for example, when Now targeted the Oak Room, Betty Friedan told women to wear fur coats in order to show that they were entitled by their class status to inclusion. Now, class, of course, is a theme that runs across public accommodations protests, right? To access consumption, you have to have money to spend in places of consumption. And as we know from the earlier civil rights movement, protesters sitting in often performed respectability, wearing suits and ties or dresses to show their status in terms of class. Now, this campaign made significant progress in this area, but encountered sites of resistance in the form of men's clubs and civic organizations, which remained sex-segregated into the 90s, fostering lots and lots of litigation, which is sort of outside the scope of this first piece, but we could talk about in Q&A if you like. So that brings us to our second theme. So feminist activists demanded the right not only to cross boundaries and enter into these previously male spaces, but also to find freedom within those spaces, and specifically freedom from compulsory heterosexuality. And public accommodations law provided them a tool. Now, the nexus between the regulation of sexuality and sex discrimination in public accommodations was perhaps most obvious in bars and restaurants. So sex segregation of these spaces aimed to create a sexuality-free zone, assuming, of course, heterosexuality. So within this logic, women were both sexual threats and sexual prey. As the owner of one bar explained in 1971, a woman could sit at his bar, quote, only if she's waiting for her husband or boyfriend. Any other woman might start talking with a man, and then the liquor commission might assume that she was soliciting. Now, bars feared that single women were there for a pickup or even to solicit. Dining and athletic clubs asserted the need for men to have their own spaces free of heterosexual distraction, where they could be safe from running into last night's dates. Plus, they said their wives wouldn't want them attending club meetings if other women were members. In the early 1970s, activists successfully used statutory prohibitions and new interpretations of the Equal Protection Clause to challenge these stereotypes about women's sexuality. In lawsuits, feminists argued that women's presence was not a sexual nuisance as defined under liquor licensing laws. For instance, when one hotel defended its no unescorted women at the bar rule as necessary to maintain, quote, the dignity of the room. Now's lawsuit posed the question, is being a woman disruptive? Courts rejected both the moral and the protectionist rationales for excluding women from bars. A court sided with feminist lawyers in a case brought under the Equal Protection Clause against McSorley's Old Ale House, a 114-year-old New York City institution that had hosted mayors, poets, and other luminaries, but had never once served a woman, including its female owner, who had never entered the bar. The court in that case concluded stereotypes, quote, of women as particularly delicate and impressionable creatures in need of protection from the rough and tumble of unvarnished humanity will no longer justify sexual separatism. At least to this extent, women's emancipation is recognized. This was actually a groundbreaking case because it was 1969, before the Supreme Court had ever found a classification based on sex unconstitutional, before a court of appeals had yet to do so. So this was actually quite groundbreaking as a case. Now, feminist activism challenged sexual norms not only by seeking access to public accommodations, but also by doing so on their own terms. So for many activists, freedom here meant flouting gendered dress codes that regulated gender performance and female sexuality. For instance, prohibitions on wearing pantsuits, because that would mean dressing like a man, but also prohibitions on miniskirts, because that would mean dressing like a prostitute. So immediately after their enactment, public accommodations laws were used by both men and women to successfully challenge dress requirements. This is a different history from the history we see with Title VII of the Civil Rights Act in employment. So long-haired men, women who didn't want to wear bras, men who sought not to wear ties, all successfully invoked public accommodations law. So with this legal reform, what once was shocking, like women in pantsuits or men loosening their ties in front of women, quickly became normal. Now, the norms that enforce this sort of compulsory heterosexuality also extended to economic and civic realms. For instance, companies discounted wages of the wives when they lent money to married couples. Insurance companies would issue family policies only in a husband's name. And when a woman married and had a life insurance policy that they had purchased when single, it would switch to the life term of the husband upon marriage. And many women understood these practices to be both economically injurious and insulting. They enforced dependence within marriage and made divorce much more difficult. So one woman wrote to a credit company that refused to issue a credit card to her in her own name, a common and much complained on of practice in the early 70s. She and her husband had, she said, excellent credit, but credit is not the point. The name is the point. Surely you must grant that I, a female, possess a name and the right to use it. Credit and insurance were among the areas most resistant to change under public accommodation law. Courts often held that non-discrimination meant that companies had to extend credit and insurance to both males and females. And indeed, it did help address the name issue, for instance, or additional requirements imposed particularly on married women. But it didn't go so far as to affect, for example, the content or pricing of insurance policies, a problem that persisted and to some extent persists today. So thus far, we've seen that women demanded entry to and freedom within public accommodations, which brings us to our final theme. So feminist activists in this period also sought to transform institutions that were modeled on dominant norms of masculinity. And we talk about both athletics and restrooms in our paper. I'm going to focus just on athletics for now. So public accommodations law proved a powerful tool to challenge sex segregation in athletics prior to the enforcement of Title IX of the Education Amendments, which began in 1975. Now activists advance what was an alternative to what we've become used to, the parity model, the separate but equal model of athletics, in which a variety of educational institutions can maintain separate sports teams. So public accommodations law has a slightly different scope. Many of them do apply to public schools. They also apply, for instance, to independent sports leagues, right? The Little League or any sort of community kind of sports league. So they apply a little more broadly, usually, than Title IX, which is limited to those institutions receiving federal funding. And then has a bunch of exceptions as well. So feminist activists using public accommodations law viewed sex integration, that is boys and girls in particular, but also men and women playing sports together, as a tool to transform standards for competition and play, and then gender roles more broadly across society. Youth sports were particularly important to these activists because of the role they play in socializing children to gender roles. Improving girls' access to sports, activists contended, would, quote, boost girls' confidence in a world that tells girls not to play or think too hard. Activists also argued that boys were raised to see girls as inferior, and in part through the organization of sex-integrated sports, they, quote, would be unlikely later on to treat women employees, co-workers, and wives as less than equal. Now, these activists did not deny that some sex difference could exist. But if you think about the early 70s, they said we don't know what those sex differences really are because women have never been given a chance to really compete, to really play athletics, and to be encouraged. So let's figure out what they are. They also argued that, of course, sex was not an accurate proxy for skill, especially at a younger age. And ultimately, they thought, if there are sex differences, then why not design games, right? That's all sports are. They're socially constructed. Let's design them to reflect both female and male excellence to the extent there are these differences. So I want to talk about one of the foundational cases in this campaign, which is National Organization for Women, Essex County Chapter versus Little League Baseball. So this is a landmark public accommodations case. This is Maria Pepe from Hoboken, New Jersey. So in 1972, a group of 12-year-old boys, the Little League is 8 to 12-year-olds, approached the coach of the Hoboken, New Jersey Little League team, sponsored by the Young Democrats. They told him that Maria Pepe, a young girl who had been playing with the boys since they were all very young, batted and fielded better than any of them. Persuaded, the coach let Pepe try out for the team, and she made it for a minute. When she briefly pitched, 2.25 million boys worldwide, mostly in the United States, played Little League. She was the only girl. Deploying what was by then its standard tactic when girls wanted to play, which was fairly frequent throughout this time period, Little League demanded that Pepe be removed from the team and then revoke the charters of all the Hoboken teams. So now filed suit. And while the league had previously prevailed against claims of sex discrimination in Michigan and Massachusetts, the New Jersey Division on Civil Rights determined that there is, quote, no reason why that part of Americana should be withheld from girls. Now, the entry of girls into it's very difficult to overstate this point. The entry of girls into male space sparked outrage among those who sought to defend boys' sports as, quote, an island of privateness and training ground for masculinity. On the pages of Sports Illustrated, writers bemoan the effects of allowing bisexual baseball. Sounds a little bit different today. The prospect of girls and boys playing together provoked what newspapers described as a wave of chauvinism and hysteria as outraged parents, players, and coaches marched by the thousands onto the New Jersey Capitol, clamoring for the state legislature to nullify the ruling. And many baseball teams suspended play rather than, as one Little League official put it, be intimidated by the National Organization for Women. More than 100,000 boys in New Jersey could not play baseball due to this ruling and the fact that their team leaders refused to be cowed by the feminist movement. Nonetheless, the New Jersey courts affirmed the order, holding that the league violated state public accommodations law when it excluded girls. Now, ultimately, the parity model prevailed. Title IX dragged us into a world of sex segregation in athletics. The Little League saw this coming. The Little League established a softball league in the middle of this litigation and tried to argue that that sufficed. Courts did not go along with that, but since the existence of that softball league, almost every girl who has wanted to play Little League baseball has been funneled instead into Little League softball and vice versa. Now, in the early 70s, integration was the hoped-for goal, not of all feminists, but of the feminists thinking about public accommodations law in this space, and a lot of actually high school girls using public accommodations law, even middle school girls. And the feminists leading this movement really thought that this would transform athletics, changing the standards of excellence into something to reflect male and female excellence. And they invoked stories of women competing in male athletic leagues and winning. And this was part of a narrative, actually, of the time period that we seem to have lost. One of the biggest arguments throughout the 20th century for letting women compete was not that they were, by virtue of sex difference, worse at athletics, but that they might be better and humiliate boys who are playing baseball or swimming or all sorts of different sports. Now, the transformative integration of sports, of course, and bathrooms and other sites of socialization has fallen short in a number of ways from where the feminist movement aspired. I just want to conclude by mentioning what we think are the major lessons of this history for contemporary debates. So first and foremost, we think this history shows that equality and public accommodations was never only a struggle about economic interests. It was always about how inclusion and treatment within the public shaped citizenship for minority groups. In addition, it shows that the struggles over sex equality were not limited to formal equality of treatment between men and women. They were here, at least, about the regulation of sexuality. And last, it shows that a vision of equality that maybe should be reconsidered is one that looks to transform institutions rather than accepting them as they are. So I thank you, and I look forward to your questions.
Is this working? Yeah, I think it is. A fantastic and fascinating talk, Liz. I was wondering if you talk a little bit about the definition of a place of public accommodation under these statutes. The federal definition, as you know, under Title II is relatively narrow, and I'm wondering to what extent were feminist groups pushing for a broad definition that would include, for example, Little League, Boy Scouts, et cetera?
So the common definition of public accommodations before Title II of the Civil Rights Act, so it had changed and grown, and there's sort of a modern language, partly because courts were recalcitrant throughout the 20th century to do what state legislatures wanted. So often, early statutes would say things like restaurants, inns, theaters, places of amusement, and other places of public accommodation, right? Or they might have a long list, right? And other places. It should be construed broadly because there's the other. And then you would have courts doing weird things, like if the legislature said saloons in the text, it was a bar, so that's different from a saloon, so the public accommodation law doesn't apply. So by the 1950s, you tend to have definitions that say something like, any place offering services, goods, facilities, or advantages to the public or holding themselves open as willing to do so. So very broad. Basically anywhere inviting the public in, where the public can expect to come in and be served on terms with others. So a very broad definition. So in one sense, the feminist movement is not changing the definition at all, and the statutes remain the same. In the other sense, we do see some expansion. So one of the questions in the Little League cases, in lots of different places, was whether a place of public accommodation meant you had to have a place, right? The Little League is at 123 Main Street. Clearly, that's not the case. They're playing lots of different places. In one sense, that was difficult. In the other sense, there were cases under Title II of the Civil Rights Act because courts did give that a liberal construction. So places of entertainment, for instance, included in at least one case that sort of had effects elsewhere, a youth football league. So there had been case law there, understanding places of entertainment broadly under Title II. But the feminist movement did push here. Boy Scouts was a target, and in some states, Boy Scouts and the Boys Club were determined to be places of public accommodation, and others not. And then we know all problems for public accommodations law come from New Jersey, and we get Dale, and the Boy Scouts weren't a public accommodation anymore, right? They ran into constitutional limits, at least. Though the Boy Scouts still, for instance, would have to comply with the law, and so far it didn't get in the way of their expressive choices, right? It's really with the private club, the men's clubs, where women most pushed on the definition of public accommodation. But reading those cases today, it's pretty clear that if they had been asserting claims of racial discrimination, there would have been no question. Obviously, the JCs and the Rotary Club were public accommodations. They let every single man who applied in. There were absolutely zero standards. So
thank you. This is such a great talk and full of so many terrible examples of things we used to do. So I guess I sort of have the same question as Carlos, which is that, and it's not in any sense a fault with the paper, but I'm curious about the origins of public accommodation law. So what is, maybe it's a basic point, but where did these things come from, and what problem prior to the civil rights movement are they trying to address? And then if we're with you that the feminist movement reconfigures public accommodations law, that leads me to a lot of questions about the category of public accommodations law in current law, right? Like, should we understand it as a federal or state category? Is it a statutory or constitutional thing? Does it make sense to talk about a single public accommodations law? Or is this, a category that's normatively overloaded, where people make political arguments by saying that public accommodations law should be X, Y, or Z? So I guess go earlier, and then you can.
So public accommodations laws essentially date from after the Civil War. Every southern state legislature adopted such a statute during Reconstruction, and a number of northern states. And then when you get but the history before that is they come out of the common law. So Joe Singer has shown, I think quite persuasively, that contrary to today's understanding of the common law as a right to exclude, right? And inns and common carriers are different, but everything else has a right to exclude. That prior to the Civil War, there was a common law duty to accept comers in any place open to the public. So there's actually lots and lots of treatises with a much lengthier list of places and a very broad definition. In fact, the definition that then gets imported into the public accommodation statute. So it's all about holding yourself open to the public, not being choosy in who you're serving. That common law gets codified, then it gets abrogated once Reconstruction comes to an end. And then in the early 20th century, so by 1900, you have 19 states that have public accommodations law. Some of them don't list race or color. They just say it's a duty of equal access in all of these places, so very much mimicking the common law. And then they change over time. They're relatively rarely enforced until World War I, when you get veterans coming back, when you get race riots, when you get lots and lots of developments in the North. So after World War I, you see a lot of enforcement and strengthening of the laws in cities and states in the North. But an enormous amount of public accommodations activity, say the 20s and the 30s in the North. And by 1950, you have relatively good compliance in urban areas and sometimes even swaths of entire states. Not perfect, but good compared to where we were. Okay, so it's state law. Public accommodations law is state law coming straight out of the common law, and partly because the Supreme Court struck down the federal public accommodation law in the civil rights cases. So it's state law, it's statutory, not constitutional. Now, the constitutional account in our story is one when state action doctrine was big, equal protection doctrine for women was new. So it's groundbreaking in that way, but today you could never try to sue a bar under the Equal Protection Clause because every court would say no state action. So that's basically where we are today. So I don't actually think our story is about a change in the meaning of or definition of public accommodations, but it's about what sex equality means in public places as opposed to housing or employment.